All right, let's go ahead and start. Let's put phones away. Anybody have questions about the papers? If you weren't here last time, we handed them back, so I've got your paper, hopefully over there. Get it from me at the end of class. I've got office hours right after class today if anybody wants to talk about anything. Obviously, at a minimum, make sure you understand whatever feedback you got on the paper, right? So if there's written comments on there that you're not sure what they say or what they mean or why we said that, then you should probably come see one of us to check in. In general, the goals of this paper are similar to the goals of paper number 2, which was about the Warren Court. It's just about a different period of time, right? So looking not at the 1950s and 60s, but looking at the past 2 decades during your own lifetimes, what are some key ways in which the Constitution has changed? Can you tell us about that? Identify the changes and describe them, but then also come up with an argument of your own about why those changes have taken place and whether they have been changes for the better or the worse. Lots of you have a good start on at least some of those things in the initial part of the paper, in the initial draft, right? So like some of you have like a good summary of some key changes that happened, but you don't really give us a clear argument yet about why they took place or whether they were changes for the better or the worse, right? So as you expand it, just make sure you're trying to hit all of those points. In addition, I have started to get a couple questions from students in office hours about the final exam. It's still a little ways off, but it'll come up quick. So I will say this. Obviously, we have only one exam this semester, and it is comprehensive in scope, so it is an enormous amount of material. As I said, if you took Common Law 1 with me, I will say something similar to what I said then. It's a lot of material, I recognize that, but I'm not trying to like quiz your like memorization of tiny little trivial facts that I mentioned in January. That is not the goal, right? The goal is to assess your ability to think about and write about some of the broad topics and concepts and themes and events that we've talked about throughout the semester, right? So you do need to know some specific details in order to be able to do that. But you don't need to memorize everything that I've said, obviously, or everything that's mentioned in the book. If you took Con Law 1 with me, we have 2 exams in that class, right? So you know what 2 of my exams look like. I'm not promising this one's going to look exactly the same as those ones, but you at least have some idea. If you did not take Con Law 1 with me and would like to see those exams, just come to office hours sometime between now and the end of the semester, and I will show you the exams from Con Law 1, so you know what those look like. Again, not promising that this one's going to be exactly the same, but it gives you some glimpse into what kind of exams I might decide to use. It's in class writing, right? It's going to be essays. Sometimes I use some short answer questions and some essays. Sometimes I use some like medium essays and then some longer essays. There's always some amount of choice. Like you get some choice between different questions. So if there's some areas of the material that you don't know as well as other areas, you might be okay as long as there's not too many of them, right? Because you'll have some choice as to which questions you're going to answer. So if you did not take Con Law 1, I do encourage you to come see me and let me show you those exams so you see what they look like. If you did take Con Law 1, you can go back and remember what they look like. Or you could come see me too and I could show it to you again. And as I said in Con Law 1, the best study guide is the daily handouts, right? You should have all of those are on Blackboard, so if you're missing some, you can get them. So that is a good study guide. And one recommended study technique is to study collaboratively. You have to take the exam by yourself, but you are allowed to study with each other. And I have had students from past semesters multiple times report to me about their study groups and how helpful it was. So I do encourage that, right? get together. You all know some of the cases pretty well, right? You can share that knowledge with each other and kind of quiz each other, and I do recommend that. Questions about any of that? All right. So we're talking about criminal justice today, which is not a topic we've spent like a ton of time on. Basically, we did one day of Warren Court era criminal justice decisions, and now we're doing one day on more recent criminal justice decisions. On reflection last night when I was working on the lecture, I kind of think that's not enough time, and I need to figure out how to free up some space to devote some more time to this. But this is what we got. So if you recall briefly our discussion of criminal justice during the Warren Court era, right? So I mean, like one whole theme from the first half of our semester is that the modern Supreme Court, beginning in the middle of the 20th century, right, started protecting expansive new conceptions of constitutional rights and liberties in ways that it had not previously done. And one good set of examples of that is in the area of criminal justice, right? And some of these decisions were pretty popular and widely accepted from the beginning. I think that's fair to say about Gideon versus Wainwright, which was the decision that protected the right to counsel. Some of these decisions were quite controversial and even unpopular from the beginning. I think that's an accurate description of Miranda versus Arizona in 1966. But either way, whether popular or not, the court was protecting expansive new conceptions of the constitutional rights of criminal defendants in various ways. Right? As we know, the text of the Bill of Rights has a lot of provisions that are about the constitutional rights of criminal defendants, and for much of the court's history, it did not enforce those provisions that successfully or actively, and in the middle of the 20th century, it starts doing so much more actively. Some of these decisions are controversial, turns into political controversy, right? They're legal controversies, and they turn into political controversies. So Richard Nixon, when he ran for president, criticized a number of the decisions of the Warren Court, including Miranda versus Arizona. Nixon got elected twice. He appointed 4 justices. His successor, Gerald Ford, appointed another one. Then we had a Democratic president for 4 years, Jimmy Carter, but he didn't get any vacancies to fill. Then Reagan appointed 3 justices, and then the first President Bush appointed 2 more justices, and Clinton made a couple appointments, and then the second President Bush appointed 2 more justices. So this is the story we've talked about before, right? If you have conservative presidents criticizing liberal Supreme Court decisions and promising to appoint a different kind of justice, then you might expect that the court's approach to these issues is going to change, right? And it for sure has changed in many respects in the area of criminal procedure. I'll give you a couple examples. In 1987, the court decided a case called McCleskey versus Kemp, which is a death penalty case from North Carolina, if memory serves. Georgia. Death penalty case from Georgia. Thank you, Vanessa. In which there was substantial statistical evidence introduced, right? Some scholars had worked with the lawyers and done a study of death penalty practices in the state. And there was substantial statistical evidence introduced that the way that the death penalty, the capital punishment system, was operating in the state was racially discriminatory, right? The race of the defendant mattered, and the race of the victim mattered even more, such that if an African American was on trial for murdering a white person, the odds of being sentenced to death were particularly high. If you were a white person on trial, or if you were on trial for murdering a black person, your odds of being sentenced to death were substantially lower. Right? And I can give you the 2x2 table. I got the numbers here, right? Black defendant, white victim, 22% of people convicted of murder in those cases were sentenced to death. Black defendant, black victim, 1%. Right? White defendant, white victim, 8%. White defendant, black victim, 3%. Right? Those are just raw percentages, but the statisticians, ran it through multivariate analysis with all kinds of controls, and they said these numbers hold up. And the Supreme Court said this does not matter, is basically what the Supreme Court said. They said it would be unconstitutional to sentence somebody to the death penalty in a racially discriminatory fashion. But all we mean by that is that you would have to prove that there was racial discrimination exercised against this person in this case. Right? This particular defendant was sentenced to death because somebody discriminated against him on the basis of his race, the prosecutor or the judge or the jury or all of them. Right? If you could show that, then we would have equal protection concerns under the 14th Amendment. But the statistical evidence by itself doesn't matter, the court said. Because that doesn't tell us anything about what happened in any one particular case, right? That's about patterns from a large number of cases over time. So this is partly a case about capital sentencing. It is partly a case about race. It is partly a case about statistics. When I was rereading it last night, I was actually thinking about the court's gerrymandering case that it's got to decide this year, where there's a lot of statistical evidence in that case about how do you decide how much partisan influence on the districting process is too much. Like, you have to prove that, like, the Republican-controlled legislature was actually, like, blatantly and intentionally trying to discriminate against Democrats in drawing this particular line in this particular place? Or do you just have to prove that, statistically speaking, the way these lines are drawn benefits Republican incumbents, like, way more than any kind of neutral set of districts would? And then, like, how much statistical evidence would be enough to make that a constitutional violation? The Supreme Court has sometimes been accused of not being very well versed in statistical matters, right? In fact, in the oral arguments in the gerrymandering case earlier this year, Chief Justice Roberts referred to the statistical evidence when the lawyer was talking about as sociological gobbledygook, I believe was the quotation from Chief Justice Roberts. Right, they might not be super comfortable with statistical evidence, so that's partly what's going on here. But partly this is a story about the court in the 1980s just being increasingly comfortable with the death penalty. Right, the court in the 1960s and early 70s was decreasingly comfortable with the death penalty and was imposing many constitutional restrictions on it. The court in the 1980s was increasingly comfortable with it and was relaxing constitutional restrictions on it. In a case in 1989 called Penry versus Leinaw, the Supreme Court said it's not unconstitutional to execute somebody who's mentally retarded. In a case the same year, Stanford versus Kentucky, the Supreme Court said it's not unconstitutional to execute a juvenile, right? Somebody who was 17 years old when he committed a murder can be executed, the court said. In a case 2 years later called Payne versus Tennessee, the court reversed an earlier decision to say that prosecutors were allowed to introduce what they call victim impact testimony at the sentencing phase of a capital trial. In capital trials, they're typically conducted in two phases. A trial is held on guilt or innocence, right? Did this person commit this crime or not? And the jury deliberates and then comes back with guilty or not guilty. And if the jury comes back with a guilty verdict, then a separate set of witnesses and testimony is brought in, and then the jury deliberates again on what the sentence should be, because usually they have some options, right? Should we sentence this person to life in prison, or should we sentence this person to the death penalty? And in an earlier case, the Supreme Court said, like at the at the guilt and innocence phase of the trial, you wouldn't introduce testimony from like the victim's surviving family members about the impact of this person's death on his like surviving like wife and children or whatever. That's not relevant to whether somebody murdered him or not. So you wouldn't allow that in. But after somebody has been convicted, Supreme Court said that information is relevant to the sentencing decision. It seems to me that that could have problematic effects in terms of exacerbating any biases that juries might have. So if the murdered person has like more sympathetic surviving family members, then you're more likely to sentence the person to death. Is the problem there. The main reason this case is widely remembered by scholars is that it was the last case, it was in 1991, it was the last case in which Justice Thurgood Marshall wrote an opinion. It was a dissenting opinion, and he accused his colleagues in the majority of reversing this precedent, which was just a few years old. It was like a 4-year-old precedent. Reversing this precedent solely because there had been turnover on the court and we got some more new justices in here, and so they're blatantly just changing the meaning of the law, not on the basis of any good legal arguments, but just because we got new justices here with different opinions. And that was his last dissenting opinion on the court, and then later that year he was replaced by Clarence Thomas, who had very different views about the court's role in protecting the rights of criminal defendants. One other example from this period, this one's in the reading. Some of these cases I'm talking about are not in the reading, but this one's in there. It's called Herrera versus Collins in 1993. Sometimes this one might be like the most, what do I want to say? I'm trying to think of a non-judgmental word for extreme, right? This is like the furthest, of all these examples I'm given, this might be the one that's like the furthest in the particular direction that I'm describing. Chief Justice Rehnquist basically said in Herrera versus Collins that it is not unconstitutional to execute an innocent person. He said, actual innocence by itself is not a constitutional issue, right? The case was about somebody who had been convicted and sentenced to death, and then later, like with a new set of lawyers, said that they had new evidence to introduce that could prove that the dude was actually innocent of the crime. He did not do it, which he had always maintained. And the court said, you can't reopen the case to introduce evidence of actual innocence unless you can show that there is some independent constitutional violation that took place at the trial, right? So was the guy denied the right to counsel? Was the jury unfairly selected, right? Was he denied the right to cross-examine the witnesses against him, right? Was there some specific provision of the Bill of Rights that was violated? If so, then that can be grounds for reopening the case, and then he can introduce the new evidence. But if you don't show any of those procedural violations, the mere fact that you claim to have new evidence demonstrating actual innocence does not merit a new trial.
And was that just in capital murder cases, or
that is a good question. This was a capital murder case, and I think that in Rehnquist's mind, he was probably thinking of all cases, but I don't remember exactly how it's phrased in here. You know, as you know, the court tends to phrase things sort of cautiously and incrementally, one step at a time, and the way it's phrased in the opinion might well limit it just to death penalty cases, but I don't remember for sure. Most of the courts, the most significant, I have another example too. It's the Eighth Amendment, right, that bars cruel and unusual punishments, and so that so most constitutional disputes about criminal sentencing are disputes under the Eighth Amendment, and the most significant of those, I guess, are capital cases, because that's the most kind of significant kind of criminal punishment that the state can impose. Although I actually have another example here of an Eighth Amendment case that's not a capital case. During the 80s, California and a number of other states, and the federal government too, passed tough new increases on criminal sentencing, even short of capital crimes, right? So even for crimes that don't merit the death penalty, ratcheting up criminal sentences, mandatory minimum sentences, higher sentences, stricter increases of sentences if you've been convicted multiple times. So, for example, a number of states passed laws that they called 3 strikes and you're outlaws. So if you get convicted for a third time of a, whatever the state says, of a violent felony or a felony or however they write the law. In California, it was if you get convicted of a third time of any felony, or they had some limitation on it, but it didn't have to be violent. Anyway, you get convicted of 3 felonies and you can be sentenced to life in prison. And you would automatically be sentenced to life in prison on the 3rd conviction. And the criminal defendant in a case called Ewing versus California was convicted for stealing 3 golf clubs from a store and was sentenced to life in prison because it was his 3rd or more felony conviction. And his lawyer made an 8th Amendment argument and made their way to the Supreme Court, and they lost. Right? So not just on the death penalty, on other matters of criminal sentencing too, the court is scaling back the protections of the rights of criminal defendants. There's examples in the Fourth Amendment context too, right? So the Fourth Amendment prohibits unreasonable searches and seizures. So the main case we talked about from the 1960s was Mapp versus Ohio, which says that if the police bust into your house without a warrant, right, they didn't, the warrant requirement, the Fourth Amendment says you got to go to a judge first. If you want to search somebody's house, you got to go to a judge first, show that there's probable cause to believe this person is engaged in criminal activity, and then the judge issues a search warrant, which is permission from the judge for the police to conduct the search. And if the police do a search without that, right, then that's an unreasonable search, and that evidence that they collected from that search can't be used. Right? It's called the exclusionary rule. That evidence is excluded from your trial because they obtained it illegally. In cases like U.S. versus Leon, which is in 1984, the court did not get rid of the exclusionary rule. They did not overturn Mapp versus Ohio. But they recognized an exception to it. In this particular case, the police officers had a warrant that was issued by a judge. And they got some evidence and they convicted the guy. But the defense counsel subsequently proved that the warrant had been based on false information and that there was, in fact, no probable cause to search Mr. Leon's home. But at the time of the search, the police officers had a warrant in their hands, and the police officers themselves believed in good faith that they were authorized to conduct this search. And the Supreme Court said in such circumstances the exclusionary rule does not apply. Right? If the police officer in good faith believed they were conducting a lawful search authorized by a warrant, then any evidence that they obtain can be introduced at trial. And on the one hand, you can see how that makes sense, because if the point of the exclusionary rule is to deter unlawful police conduct, right, it's not going to deter anything in a case where the police believe that they have a valid warrant, right? They're not intentionally doing anything illegal, so there's nothing to deter. On the other hand, creating this exception creates an incentive for police and other officers in the criminal justice system to manufacture, right, to like create plausible deniability, right, to create a system where they are able to say that they had good faith belief that the search was authorized, even if, in fact, there was no probable cause to justify it. There's also a bunch of Fourth Amendment cases during this period about mandatory drug testing, right? The court holds in a series of cases that if you are required by the government to provide a urine sample to be tested for illegal narcotics, that is essentially a search of your body or a seizure of your bodily fluids, right? It is an attempt to get evidence of illegal activity from you against your will, right? And so it's covered by the Fourth Amendment. And so ordinarily, the government would have to have some good reason, some probable cause, in order to require you to submit to a drug test. But in the 1980s, the court recognizes a whole bunch of exceptions to that rule. Right? So in a case called Skinner versus Railway Labor Executives Association, they say that whenever there's a train accident or any violation of railroad safety rules, any railroad employees involved have to take a drug test. That's a public safety exception. That seems like it probably makes sense. But then in a series of subsequent cases, they extend that. There's a case in which they say that all U.S. Customs inspectors, right, if you work for the U.S. Customs Office inspecting materials being imported to the United States at the border, you can be subjected to mandatory drug tests. And that one doesn't sound as much like a public safety exception, right? You're not driving a train, you're inspecting packages. But the court says the exception still applies, right? One of the things we're looking for is illegal narcotics coming into the country. We don't want the people doing the inspections to be using illegal narcotics themselves. That makes some sense. But it starts to sound that maybe there's some kind of like war on drugs, like exception to the Fourth Amendment. One other Fourth Amendment case, this is jumping forward in time, this one's from 2012, but it gives a good glimpse, I think, into the way that the current court has approached some of these issues. A guy named Albert Florence was pulled over in New Jersey by law enforcement officers, and then arrested for failure to pay a fine. So first of all, he was pulled over for driving while black, right? There was no good reason that the cops pulled him over in the first place. But when they pulled him over, they ran his license, and they said he had some outstanding fine that he had failed to pay, which turned out not to be true. He had paid the fine, and there was an error in the police database. Nonetheless, the police believed that he had not paid the fine. They arrested him. They brought him to the Burlington County Detention Center, where he was strip searched, as was routine practice, to make sure he had no contraband. He was subsequently transferred to the Essex County Correctional Facility, where he was strip searched again, as was routine practice, even though he's been in custody the whole time now, to make sure he hasn't found some new additional contraband somewhere. And he sued the state, arguing that these strip searches were unconstitutional, and he lost in the Supreme Court in 2012. Many of these decisions were 5-4. That one was 5-4. And they just give a glimpse that at least in some respects, at least in some areas, the court of your lifetimes, right, the court of the kind of Reagan-Bush era, was trying to cut back on the criminal rights revolution of the Warren Court. Scale it back. Questions so far? Hunter?
President Trump recently said that he was considering drug testing food stamp recipients. Do you think that would be a violation of the Fourth Amendment?
It might be. There would for sure be challenges. So there's one case, I don't think it's in the reading, I think it's called Ferguson versus Charleston, something like that. It's from South Carolina, I believe. And it was a public hospitals in the state were doing, I don't remember all the details, so don't quote me on this. I think this is basically right. Public hospitals in the state were doing mandatory drug tests of Medicaid recipients who were in the hospital, right? So folks whose health care bills were being paid by Medicaid, they were mandatory drug testing them, especially pregnant women, on the theory that drug testing is harmful to the fetus, and once the baby is born, it can be still harmful to the baby, right? There are babies, if a pregnant woman is using cocaine, right, babies can have withdrawal symptoms after being born, right? So there is a medical issue there, right? That was the purported justification. But the hospital authorities were not using the information just to guide their treatment. They were turning the information over to law enforcement, and there were pregnant women getting arrested at the hospital, having had their blood or urine tested without their consent, and then the police arresting them for illegal narcotics use. And that was challenged under the Fourth Amendment, and they won. The Supreme Court struck that one down. So part of the theme of today's lecture is that there's a bunch of areas in which the court has cut back on the rights of criminal defendants, but it has not gotten rid of those rights, and there's other areas in which the court has continued to protect them. And so for this particular example, could you drug test food stamp recipients? The way the court would approach it, I think the answer would probably be no, you can't do that, although I don't know for sure if the current court would say that. But the way the court would approach it is they would say, if they don't overturn Mapp versus Ohio, then the exclusionary rule still exists, right? But they would say there are some circumstances in which some kind of like special needs of the government, other than just law enforcement goals, justifies exceptions to the Fourth Amendment rule. So the reason you're allowed to do mandatory urine tests of people who drive trains is for public safety, not because you're trying to arrest illegal drug users. That's not the reason you're doing that. You're trying to prevent trains from crashing, right? And so could the government come up with some... in the South Carolina hospitals, they tried to say, the reason we're doing this is for public health, right? To protect those newborns from, we got to know if they're suffering from cocaine withdrawal when they're born. And the court was like, yeah, but then why are you turning the information over to law enforcement, right? So those would be the kind of arguments that the judges would look at in that case. Ferguson versus Charleston. I do have notes on that one. There's been subsequent disputes about Miranda versus Arizona. As with Mapp versus Ohio, right? So Mapp versus Ohio is the Fourth Amendment exclusionary rule. The court does not overturn that, but they do try to cut back on it by creating a bunch of exceptions in different circumstances. Same basic story with Miranda versus Arizona. The most significant case from your lifetimes, or roughly your lifetimes, about Miranda is Dickerson versus United States, which is in 2000, in which the court reaffirms Miranda. And Chief Justice Rehnquist, who had long been critical of Miranda versus Arizona, he's the one who writes the opinion reaffirming it. So they do not overturn it. But meanwhile, in other cases, they do carve out some exceptions. Well, but if the police are questioning you this way and not this way, well, then it's okay that they failed to read you your Miranda warnings. Oh, well, if the police read you your Miranda warnings once, and then you were in the lockup, and they came back, 3 days later, and you still haven't been bailed out, but they had new questions, and they questioned you again, and they didn't read you the warnings again, that's all right. The court, that's okay. That you don't have to throw out the testimony there. So the court, scales it back, carves out some exceptions, but it does not overturn the precedent. Same basic thing with Gideon versus Wainwright, which is the right to counsel case. The court does not overturn that. And in fact, this is one of these ones where, there's lots of questions about how well realized the right to counsel is in practice. But formally, legally, everyone pretty much agrees now that you have a right to an attorney, right? Gideon versus Wainwright is very well established, right? You cannot be convicted for any kind of serious crime if you don't have a lawyer to help represent you. The kinds of disputes now that come up about right to counsel are not where the state has refused to provide a lawyer at all, which is what happened in Gideon, right? The guy robbed a cash register and the state convicted him and they would not give him any assistance of counsel at all. That doesn't really happen as much anymore. The thing that comes up now is what counts as providing counsel, right? They can't just stick a dude in a chair next to you, right? Put a sign on him that says lawyer, right? There's got to be what is actually required. Can he be asleep There have been cases about this. Oh yeah, the state gave me a lawyer and he slept through substantial portions of the trial. Has my right to counsel been denied? Some of the judges are like, no, they gave you a lawyer. Yeah, that was part of his trial strategy. Who's to say, right? You had a lawyer, right? But some of the judges are like, wait a minute, right? There's got to be some minimal standard. The phrase that they use is effective assistance of counsel, right? In order for us to say that your right to counsel has not been violated, not just the dude sitting next to you in a chair, right? Some minimal effective assistance of counsel. Here's a good case from 2010 that illustrates that. It's called Padilla versus Kentucky. Jose Padilla was born in Honduras, but had lived in the United States legally for more than 40 years. He had served in the U.S. Army during Vietnam. He was a lawful permanent resident. He was not a U.S. citizen, but he was a lawful permanent resident, legal immigrant. He got arrested and charged with marijuana trafficking, and his public defender advised him to accept a plea, which, as you know, happens quite regularly. Vast majority of criminal defendants who are indicted, they plead out, right? The prosecutor says, if we go to trial and you get convicted of this maximum charge, you could have life in prison or whatever, but I'll agree to a lesser charge if you plead guilty, and you'll only get whatever, 10 years or something. Happens all the time, every day. Public defender advises him to accept the plea offer from the prosecutor. Mr. Padilla asks his public defender whether this would have any impact on his immigration status. And the lawyer says no, which is wrong. Drug trafficking at the time, and still, was considered an aggravated felony under federal immigration law, and a conviction for any such crime leads to more or less mandatory deportation, even if you are a lawful permanent resident who's been in the country for 40 years. And so he was convicted. He pled guilty, and then U.S. immigration authorities initiated deportation proceedings against him. And he got a new lawyer. Somebody provided him with a new lawyer, and he challenged this in court, and he made his way to the Supreme Court, and he won. They threw out his conviction. He pled guilty on the basis of advice from his lawyer, state-appointed lawyer, that was so blatantly incompetent as to be as if the state had not provided him a lawyer at all, right? That is not the right to counsel, right? To give you a lawyer who gives a blatantly wrong answer to a direct legal question that has the effect of you're going to be deported, right? They throw out his conviction, right? That is not effective assistance of counsel. Quentin?
What was the reasoning behind the lawyer that we didn't know that immigration would be affected?
He was a terrible lawyer. Yeah, he just didn't know. I don't know all the background, but it is not uncommon that public defender systems. There are many really awesome, amazing, dedicated public defenders. There are also some who are less good and less dedicated. And it is also true that whether they're dedicated or not, they are often overworked and handling way too many cases. And so, they miss deadlines or something like that. So, now you can't appeal the conviction because your lawyer missed the deadline. That kind of stuff happens a lot. In this particular case, at least the way it's described in the Supreme Court's opinion, it sounds like incompetence. It sounds like he had handled lots of criminal defense work, but maybe never for immigrants, right? And so the immigration thing had never come up in his experience. He could have looked it up, right? Which is what a good lawyer would do. Let me look in the law book. But he just said, no, there'll be no effect.
I just wanted to ask this question. So if in your case in this case, the state doesn't provide an immigration lawyer?
So the trial, there was no trial because he just pled guilty, but the criminal proceeding initially was not an immigration proceeding at all, right? It's just he's been indicted for drug trafficking. So just a public defender is provided, and then once he pleads guilty, he's now been convicted of an aggravated felony, and then a separate immigration proceeding gets launched. It is also the case that the court has not really extended the right to counsel into immigration matters, right? The right to counsel is basically an issue of criminal prosecutions under Gideon versus Wainwright. And so there are lots of immigration proceedings that happen where folks do not have legal representation. Yeah, what?
Did he ever, was there like a retrial? Because he did take the plea, but then, he still never had his actual trial. Like, he could have still been convicted if he didn't take the plea.
He could have still been convicted. So I don't know what happened to Mr. Padilla in this case, but in the vast majority of the court's criminal procedure decisions, if they rule in favor of the criminal defendant, what they do is they vacate the conviction. Right? They nullify the conviction, or sometimes they don't even nullify the conviction. Sometimes they just vacate the sentence. Right? Sometimes it's the trial was fine, but the capital sentencing part, they did something unconstitutional. So he's still convicted of murder, but he's no longer has any sentence imposed at the moment. And then whether they vacate the sentence or the conviction or both, they send it back to the lower courts, and they say, you figure out what to do next with it. Right? We're telling you what the law requires. We're telling you what you messed up in the previous trial, but he can still be tried again. So famous example is Ernesto Miranda is tried again and convicted again. Right? They're just not allowed to use that evidence from the coerced interrogation. Right? That was the constitutional violation. But if they have other evidence that he committed the crime, you can try him again. It's not double jeopardy, right? It's not double jeopardy. You're not trying someone twice for the same offense. He hasn't been acquitted, right? He was convicted or he pled guilty, but the court just vacated that because of the constitutional violation. So you're allowed to try them again. So in Mr. Padilla's case, I don't know what happened, but he could well have been tried again. But at least now he would have, if he had effective legal representation, they would say, well, now he knows anyway, right, that if you are convicted of this crime, you can be deported. And so probably you are then going to choose not to plead guilty. You're going to choose to go to trial, and hopefully you can, I don't know whether he did the crime or not, right? If he's hoping, well, I got a chance to get off if I have a trial at least. So in some areas, the court is significantly scaling back on the criminal rights protections of the Constitution that were expanded during the Warren Court era. In some areas, the court is kind of holding steady or chipping away at the margins or a little bit, right? So none of the major Warren Court precedents get overturned. Mapp, Gideon, Miranda, none of those have been reversed. Some have come close. There was a decision where 4 justices said we should get rid of the exclusionary rule. We don't think that works. We don't think we should stick with that. But none of them have been overturned. And in some areas, I think it's probably fair to say that the current Supreme Court has expanded on the criminal rights protections of the Warren Court era. I've got 2 kinds of examples. One kind of example, I know at least a couple of you are writing about this for paper number 3, is areas where the emergence of new technologies has sort of created new constitutional questions or just forced us to answer the same old constitutional questions but in a different context with a new technology that didn't exist before. Right, so this has happened throughout the court's history, right? So telephones, once upon a time, were a new technology. In the early 20th century, the court had to decide whether if the government is listening to your phone conversation without your knowledge, does that count as a search? And if so, do they need to have a warrant, right? And there's a whole wide, ever-expanding range of potential forms of electronic surveillance that the government has the capacity to engage in now, and the court has to decide whether and how the Fourth Amendment applies to some of these scenarios. So just a couple quick examples. In a case called Kylo versus United States in 2001, Supreme Court says that if law enforcement officers are using thermal imaging devices aimed at your home to determine whether a large-scale marijuana growing operation is taking place inside, because the heat lamps that you're shining on the pot plants show up on the thermal imaging devices, that is a search. the Supreme Court said. The police can do it if they have a warrant, right? So they got to have probable cause before they can shine the thermal imaging devices on your house. They got to have probable cause. Now, is this a question about new technology? Yes and no. Right? There's also a case, maybe a couple cases, about like drug sniffing dogs. You know, can the police bring a drug sniffing dog up onto your porch to like smell around the entrance to your home without a warrant? And the Supreme Court has said no, they need a warrant for that too. That's not really new technology. I don't know when they started training the dogs to sniff drugs. Dogs are not new technology, right? So it's not just about new technology. It's about the Fourth Amendment principle, but there's always new contexts in which it's coming up, right? There is a case called U.S. versus Jones, which is about GPS tracking devices. Can the police put a GPS tracking device on your car to monitor your movements without a warrant? And the Supreme Court says, no, they cannot do that. Right? That is not really a search exactly, but it is an effort to collect evidence from you in pursuit of some law enforcement investigation against your will. So it is akin to a search. And the police can't do it without a warrant. The opinions in U.S. versus Jones are interesting. The case was unanimous, I think, but the justices could not agree on the reasoning in it. There's basically two different arguments, so there's two different main opinions, where some of them are like, oh yeah, police can't do this for this reason, and the other group is like, no, police can't do this, but for a completely different reason. Some of them argued that sticking something on your car without your permission is an invasion of your property rights. Right? The car belongs to you. Like, why is law enforcement allowed to come stick something to it without your permission? Right? Property rights. The other group argued that excessive governmental monitoring of your movements is an invasion of privacy. Even though it would be lawful for an unmarked cruiser to tail you wherever you go, right? If in the course of a criminal investigation the police are staking out your home, there's some dude sitting in a van, police officer sitting in a van across the street, and whenever you drive somewhere they follow you, that's not a search. The court has said they don't need a warrant for that. But the technological leap that is enabled by GPS tracking devices enables them to give so much more. Right? There's only so many police officers with only so many hours in the day, only so much overtime budget, right? They're not going to tail everybody for weeks and weeks and weeks, right? It's a power that's difficult to abuse because it's expensive. The GPS thing is cheap, and they attach it to everybody's car, and then with a push of a button, they can see where everybody went, like all year long, right? It doesn't cost hardly anything once it's set up, right? And it gives them the capacity to collect way more private information about people than previously would have been feasible. And so that's a Fourth Amendment privacy issue, the court says, and they need a warrant for it. There are similar disputes that have come up about smartphones, right? Ordinarily, if you get arrested, the police can search you, right? In fact, the court says in 1968 the police can search you they can search your person even if they just stop you for questioning and have not arrested you, right? If the police observe something suspicious and they stop you to question you, it's called stop and frisk for a reason, right? They stop you and they frisk you for the law enforcement officer's own safety. And the Supreme Court has held that that's okay. Then if they do arrest you and they bring you downtown to the lockup, Supreme Court has said they can search you again and more thoroughly, and even, in the case I mentioned earlier, they can conduct strip searches, right? Because they don't want people bringing anything dangerous to themselves or others into the jail, right? And so, again, the police officers have arrested you, they bring you downtown to the jail, before they book you and put you in the cell, they can search you. Obviously, they don't have a warrant yet. They just arrested you because they caught you like robbing a cash register, and saw you running out of the store, right? They haven't been to the judge yet. They don't have a warrant yet. They can't go search your house, right? But they can search your person when they're booking you, ordinarily. But nowadays, on your person, in your pocket, you have digital records of all of your personal correspondence and all of your business records, right? If they make you give the passcode, right? They could gather so much additional information about you. Supreme Court says the Fourth Amendment applies here. They can't do that without a warrant. They can take your phone from you and stick it in a box. They don't have to let you keep it in the cell. But they cannot make you provide the passcode, and they cannot search its contents in the absence of a warrant. The Supreme Court has said. And then there's a case that's at the Supreme Court right now, which a couple of you wrote about, Carpenter versus United States, in which the question is whether whether the law enforcement officers, without a warrant, can go to your cell service provider and request records revealing the location and movements of your cell phone over some specified period of time. In this particular case, Carpenter versus United States, it was over the course of 127 days. Right? AT&T or Verizon, whoever, give us all the location data for the past 127 days on this cell phone number. Right? With a warrant, they could obviously do that. But the police here were trying to do it without a warrant. And that is the Fourth Amendment issue that the court's got to decide in Carpenter versus United States. And if you read their opinions in, so the one about searching the contents of your cell phone is U.S. versus Riley in 2014. And that one I'm pretty sure was unanimous too. Right? No, they cannot search the full contents of your cell phone without a warrant. Yes, they can do it with a warrant, right? Convince the judge that there's probable cause to believe that there's evidence of criminal activity on that phone, then they can search it. But they got to get the judicial permission first. Law enforcement officers can't just do that on their own. So one would think that maybe the court would rule the same way in Carpenter, but we don't know yet. Questions about any of that? Who wrote about Carpenter? Yeah. Anything else from that case that I'm not touching on? You guys remember? Yeah.
Well, so they used a really specific law to kind of justify not getting the warrant. It was a Digital Communications Act from the 1980s that said something about cellular calls. Something about them didn't require a warrant. But they hadn't updated that law.
Right, which is pre-smartphone era, right?
Yeah, and their argument about that is you really willingly gave up that information when you signed a contract with your cell phone provider.
Yeah, this is one of the things that came up in the oral arguments at Carpenter, where the court has repeatedly said, so Fourth Amendment cases are partly about protecting privacy, right? And so the court's trying to decide, well, what counts as privacy? The phrase that they often use is what counts as a legitimate expectation of privacy. If I am walking down the street, shouting at a friend walking next to me, and we are both, shouting things that provide evidence of criminal activity, right? And there's a police officer walking nearby, and he hears it, we do not have any reasonable expectation that whatever we're saying out loud is private. We're on a sidewalk shouting, right? The police officers can use that evidence against us. They don't need a warrant to use that evidence. There's no expectation of privacy there. And so one of the things the court has sometimes said is, well, if you voluntarily share some information with a third party, right, then you are no longer treating that information as private, right? If there's some private business records, in a drawer in my desk at my house, then I think those are private. If I bring those to a meeting and make some copies and hand them out to a bunch of people, then I have shared them with third parties, and then I don't have the same expectation that those are private anymore. And so the court in some prior cases had suggested that when you make a phone call, right, old-fashioned phone call, landline from your house, right, you are sharing with the phone company voluntarily the numbers of the people you are calling, right? That's how the call gets connected, You are telling the phone company, I want to talk to this guy. I dial these 10 numbers, and that's how they connect it, right? And so you don't have any reasonable expectation that the numbers you have called are private. That's what the court said about regular phones a while back. And just the thing is, with the technological changes, it forces people maybe to think about it a different way, right? They're like, phones nowadays are not just phones, right? There is so much information connected to them. It is like not quite impossible, but it is very difficult to function in contemporary society without owning a cell phone. And the fact that you have like signed the boilerplate contract with your service provider, that means you have agreed to like abandon all expectation of privacy for every number you call, every email you send, every place that you go with the phone in your pocket. That sounds to many people to be unreasonable, right? Like, why? Nobody is really giving up that expectation of privacy. They're not like intentionally sharing all their movements with a third party, right? The phone in their pocket does in fact share all their movements with their cell service provider. Some people don't even know that. Some people know it but aren't thinking about it and would still like to maintain that privacy as much as they can, but there is no other way to get a cell phone that works without signing a contract with one of the providers.
What about like, so like with our cell phones, like there's even like, obviously I agree, like that's we're not intentionally sharing that information, but like you know, they like listen like through the microphone like when you're not using it.
Yeah.
It's very clearly unintentional sharing of information.
Sure. And the whole dispute's about Facebook right now. Like, so I read it somewhere in the news over the past couple weeks, right? Mark Zuckerberg's been testifying to Congress that if you have the Facebook app on your phone, then Facebook has data on every phone call that you have placed from that phone. Not phone calls placed through the Facebook app, regular phone calls from the same device. Facebook has all of those numbers and the time and duration of every one of those calls. And it sells that information to other people, right? And so, like, no, lots of people don't even know that, right? So it's for sure not voluntary, and it's like technology companies play such a powerful role in most of our lives nowadays that they are potentially as big a threat to important rights like privacy as the government is, right? We don't want the National Security Agency listening to our secret phone calls unless they have some good reason to do so. But we don't want Facebook doing it either, right? Why does Mark Zuckerberg have the right to do that just because I got the Facebook app on my phone, right? It raises really significant questions.
Did he actually say that he was had data on all of our phone calls?
No, he didn't say that.
Okay.
But
Was it one of those assumed things, or did you just?
Well, so a couple weeks ago, this is before the testimony. I'm not the right one to answer any of these technological questions. I'm like a minimalist Facebook user. But there was like something came out where you can like request your Facebook file or whatever. Yeah, I don't even know what it's called. But people were doing that, and then the thing they were getting like listed every phone call that they had made from that device. You know, not stuff from the Facebook app, right? Other things from that device. That's all I know. Talk to somebody in the computer science department or something for more on that.
Back to the point about sharing, when you sign a contract, you're sharing. Anyone make the comparison between mailing something to the postage service? Because you're technically sharing your letter with them.
I think the distinction, I don't know for sure, but I think part of the line of argument would go like this, right? The U.S. Postal Service, when you mail a letter, you have no expectation of privacy with regards to the identity of the person you're mailing a letter to, because their name is on the outside of an envelope. You do still have an expectation of privacy with regard to the contents of the envelope. You sealed it, right? You're not waving the letter around in the air. It is in a sealed envelope. You expect that to be private. You do not expect the government to be surreptitiously opening the envelope and reading the letter. And so the analogy to phones, and this is something that's come up in some of the NSA wiretapping disputes, right, is there's a difference between the content of your phone conversations and the metadata. The metadata is who did you call, when did you place the call, how long did it last. And the court is still figuring out how it's supposed to respond to all this new technology, but like one plausible distinction that would be rooted in existing law is to say, under ordinary circumstances, folks do have a reasonable expectation that the content of their phone calls is private, but they don't have that reasonable expectation with regards to who they're, right? But many of us, I think, would say we want all of that to be private, right? And so that's going to require the court to like tighten the Fourth Amendment to continually respond to this new technology, or probably it's going to require also Congress to pass some new laws, government, right? If the rules governing like cell phone location data are based on a federal law from the 1980s, when cell phones were like this big and like had to be like attached to your car, like that, I think that law probably is not currently adequate, right? Somebody else have a hand over here? Yeah.
I was just saying that last argument was brought up in one of the carry briefs from the Electronic Rights Foundation.
Oh yeah.
About that one.
With the one about
the post office.
Yeah. Oh, okay. Okay. Interesting. So one other set of examples that I want to get on the table is the court in recent years has revisited the death penalty too, right? Not as a whole. Right? The court has not said that the death penalty is unconstitutional. But the court, in a series of recent decisions, has imposed limits on when and for whom the death penalty can be used. In a case called Atkins versus Virginia in 2002, the Supreme Court said you cannot constitutionally execute somebody who is mentally retarded, which reversed the decision from 1989 in Penry versus Linehoff. In a case called Roper versus Simmons in 2005, the Supreme Court said the same thing for juveniles. If somebody was a teenager, not a legal adult, when he murdered somebody, he cannot constitutionally be executed for that crime, overturning Stanford versus Kentucky from 1989. In a case called Kennedy versus Louisiana in 2008, the Supreme Court said you cannot impose the death penalty for crimes other than murder. Right? Death penalty is allowed for murder convictions, first-degree murder, but other serious violent crimes, rape and the like, death penalty cannot be imposed, Supreme Court says. And then in another case that's not a death penalty case, a case called Graham versus Florida, in 2010, the Supreme Court said you can't impose a sentence of life without parole on a juvenile convicted of a non-homicide crime. Right, so that like combines together pieces of a couple of those other. Right, one said you can't execute juveniles. One said you can't execute people convicted of non-homicide crimes. And then a subsequent case says you can't even sentence to life without parole a juvenile convicted of a non-homicide crime. Right, so all of them are scaling back the situations in which the death penalty or life without parole are allowable. And there's two really significant things about these cases that I just want to highlight. One is that the Supreme Court emphasizes that a national consensus has developed against the execution of certain kinds of criminal defendants, right? Against the execution of juveniles, against the death penalty for crimes that did not involve murder, against the execution of the mentally retarded. These punishments used to be constitutional, the Supreme Court says, but our thinking has evolved. Not our thinking, not the justices' thinking. I mean, maybe theirs too, but that's not what they mean, right? America's thinking has evolved, right? Our society's thinking has evolved. Justice Stevens writes the opinion for the court in Atkins, which is no death penalty for the mentally retarded. And he says, a claim that a punishment is excessive is judged not by the standards that prevailed in 1685 when Lord Jeffreys presided over the bloody assize or when the Bill of Rights was adopted, but rather by those that currently prevail Lord Jeffreys convicted and sentenced to hanging 300 people in 1685 in England. He was called the hanging judge. That's not how we judge what counts as a cruel and unusual punishment, by what somebody could be hanged for 300, 400 years ago. The way we decide what counts as a cruel and unusual punishment is based on the evolving standards of decency that characterize our society. That quote is from an Eighth Amendment case from the 1950s called Trapp versus Dulles, and the court has returned to it again and again. Right? The Eighth Amendment is not the only area of the Constitution, but it's one of the clearest, I would say, where the court, at least since the 1950s, over and over and over again, the court has said the meaning of this provision evolves over time. Right? What did the framers think was cruel and unusual in 1789? What? Really? Is that what we're going to go by? Lock somebody up in the town square, in a stock, right, with their head in their hands, locked in circles in a board, right, while people throw stuff at them, right? That is not what we're going to do, right? What was considered cruel and unusual in the 18th century is not going to be the sole guide to what we consider cruel and unusual today. The words of the provision say, "Nor shall cruel and unusual punishments be imposed." Right? It doesn't list some specific set of punishments that are prohibited. It's an abstract guarantee against the infliction by the government of cruel and unusual punishments. And so we have to decide what cruel and unusual mean. And we are not going to decide it based on something that happened just in the 18th century. Right? We're going to decide based on our society's evolving standards of decency. Now, how do we find these evolving standards of decency? The main thing they look at, sometimes they make some reference to public opinion and such. The main thing they look at is state legislative changes. Well, some states have abandoned the death penalty altogether, and even the states that still use the death penalty, many of them have abandoned it for juveniles. Right? So states voluntarily, in their state legislature, have modified their capital punishment laws to say, well, these laws can only be applied to people who are at least 18 when they convicted the crime. Not every state, right? But an increasing number in a clear and consistent trend over time have said that is a practice we're not going to do, right? And so it's obviously not every state, because if it were every state, then there would be no case at the Supreme Court raising the issue, right? There are some states that are still trying to sentence juveniles to death, and the court is saying, yeah, this handful of states that's still trying to do this, they're not allowed to do that anymore because our country's consensus has evolved. The other thing that's really significant about these opinions, and that's related to that point, is that the court makes reference not just to developments in the United States, but to developments elsewhere in the world as well. Take a look at the quote on your handout. So this is from Roper versus Simmons, which is the one about no death penalty for juveniles. So go ahead and read that one real quick. When we say that the Eighth Amendment is going to be interpreted in accord with the evolving standards of decency that characterize our society, we mostly mean our society, right? We mostly mean the United States. That is mostly where we're going to look. However, it might also be instructive to note that the vast majority of the human population on the planet, right, has also abandoned these practices. Right? Since 1990, only 8 countries have executed juveniles. Right? Iran, Pakistan, Saudi Arabia, Yemen, Nigeria, the Democratic Republic of Congo, China, and the United States. Right? And most of those countries have since abandoned it. Right? There's international treaties that almost every country in the world, not including the United States, have signed that prohibit it. Right? We are not saying that the United States has to do exactly what the rest of the world does. We are saying that it might be instructive to pay some attention if we are trying to figure out what the phrase cruel and unusual punishment means. It might be instructive to pay some attention to what kind of punishments are considered tolerable in other parts of the world. And if all of the countries that we ordinarily consider friends and allies, and similar in some respects to the United States, have concluded that the death penalty in such cases is illegitimate, should no longer be practiced. Maybe that's something we can learn from. Every time the justices do this, there are a handful of modern cases, during your lifetime, in which the justices have made direct reference like this to foreign legal developments as an instructive thing that maybe we would want to follow. Every time they do it, it's controversial. Right? Some of the judges on the court and some politicians who are critical of the court are like, what the heck are you doing? Why are you doing that? We don't got to do whatever France does or whatever. We're interpreting the U.S. Constitution. That's what you're supposed to be paying attention to. It doesn't matter what any other country in the world. I don't care if none of them execute juveniles. If we think it's constitutional under our Constitution, we should do what we think. Right? It's always controversial. Almost every constitutional court in the world, other than ours, regularly pays some attention to what courts in other countries are doing. Right? Well, what other countries have decided the same basic question, let's see what they said. Not that we have to do it the same way, but let's pay some attention. Our Supreme Court does not do that very often. And when it does do it, it's crazy controversial. But these cases, I think, are a good glimpse of why it sometimes might make sense. Right? Again, not to say that we got to do what the other countries are doing, but is this a cruel and unusual punishment, or is it not a cruel and unusual punishment? Does it seem relevant that like 190 of 200 countries in the UN have like long abandoned it, and even the other 10 like barely ever use it anymore? That seems like it might be relevant, and that's what Justice Kennedy is trying to drive at there. That's all. Oh, and if you weren't here last time, I got your paper.